Talk.
Well, first of all, I'd like to give you an official welcome to this first annual American Constitution Society Symposium. I have to say I'm really delighted and I'm honored that we could be the host of this symposium. Needless to say, this is an auspicious moment to be discussing all of these different issues. The United States historically has always been engaged in constitutional debate at almost every moment. That's sort of the distinctive feature. But I don't think I'm telling anybody here anything they don't know. This is one of those special occasions when the level of debate and the significance of the debate is quite different. We are at a moment when political forces and institutions are focusing on major questions that I think have not been thought about for a very long time. And obviously there are a number of issues facing our society, which we all know about, both on a political and an economic level, that are going to require us to explore in greater depth and come up with answers that are going to be quite new. In sort of technical terms, this could well be a constitutional moment. And I suspect that the nature of the political debate in places like this, as well as in Washington, is going to tell us a lot about what's going to happen over the next 4 years. I should say, in light of that, it's incredible to see the participants who are here today, many of whom I know, all of whom I know of and have read their work. I can't think of a better group of people. And I suspect many, if most of you, will be involved in discussing these issues over the next 4 years. And some and many of you may be having your cell phones on as you get calls from the Obama administration about joining them in that discussion over the next 4 years. I would say, in light of all this, we're truly honored here at Penn that we're able to host this. As you walked up the steps here, you may have noticed to your left was the first law professor at the University of Pennsylvania, James Wilson, a framer of the Constitution and Supreme Court Justice. He taught his first class here to Washington's cabinet. That was the first constitutional law class here at Penn. Penn has not only a great constitutional history within the law school, but our relationships both with the history and political science department are deep and long-ranged. And I'm glad that both people from those two departments could participate. And then, of course, finally, the National Constitution Center, which has become the Center for Constitutional Debate, is partnering with us in this. And then finally, I want to thank specifically Miriam Nemeth, who has done a phenomenal job here at Penn, as well as Rachel Zurau in bringing this here, and the staff of the American Constitution Society. So in any event, this is really a perfect group of people to be discussing this issue. It's the perfect time to be doing it and the perfect place, so obviously I should get out of the way and do what I'm supposed to be doing in a moment like this, which is going out and fundraising to fund things like this. Yes. Unfortunately, this is not an auspicious moment for me to be doing what I do, fundraising. In any event, I'm absolutely delighted and honored that you're here, and let me turn it over to the panel for the first symposium conference today. Thank you.
Thank you very much. Peggy, why don't you come on up while we send the dean off to raise money. I'm Mary Frances Berry. I am a lawyer and a historian, and I teach courses in history of American law, among other things, in history of law and social change in the history department, and on occasion, when I cannot avoid it, in the law school. But I'm primarily a historian, a legal historian who's in a history department. And I also have had a quite public career, which is described, as everybody is described, in the materials that you were given, so I don't have to read bios of myself or everybody else. I did want to point out to you that my most recent book, which is a published book, is a book called My Face is Black is True, which is a history of struggle for pensions as reparations for ex-slaves in the 1890s. And I have a new book, which may interest you, coming out from Knopf in January, called And Justice for All. Very unusual title. I don't know how he thought of it, and Justice for All. And it's a history of the United States Commission on Civil Rights and the role it played interacting with presidents and civil rights protesters in the struggle for civil rights in the country. It's called And Justice for All. The other thing I'd point out is that when I was asked to chair this panel and we were sent the prompts for the session, it of course quotes from the Slaughterhouse case and talks about the one pervading purpose, the rights of blacks, and raises questions, as this panel does, about what other groups under the 14th Amendment, and talks about the original understanding. And I only wanted to make 3 points before I introduce the first speaker. And those 3 points are, one, that whenever anyone mentions original understanding, and I think you had a session on that yesterday, in my class, I make them go read an essay by a guy whose name I think is Jefferson Powell on the original intent of original intent, and that the original intent of the framers was that we not look for their original intent based on the history of it. I think that's an essay. If you have not read it, sometimes you might read it. It's very informative and witty. The other point I'll make is that I very much understand being careful about the history of the 14th Amendment and its Equal Protection Clause and whether it applies to blacks and other groups, primarily because in the 1980s, during a great battle between myself and the Reagan administration, Morris Abram, who was vice chair of our commission, wrote an article in the Harvard Law Review in which he denounced me as a social engineer. And when I saw the label, I was happy because I thought Charlie Houston might be very pleased about me being called a social engineer. But anyway, that I was a social engineer because I said in an opinion that I published for the Civil Rights Commission on one of our reports, along with a woman named Blandina Ramirez, I said that civil rights, the history shows that civil rights laws were not passed to give civil rights protection to all Americans, but that they were passed primarily as a response to the situation of African Americans, blacks. And he denounced me for saying that and saying that civil rights laws applied to everybody, and I had to write letters and go to a hearing in the Senate where I was called and taken to task for saying that the history of civil rights laws had something to do with blacks, and I had to renounce all of my opinions and say that I was talking about history. So I'm very much aware of that. And then the third point I would make, finally, is that as Christopher Edley, who's dean at Berkeley now, is a good friend of mine, Bolt Hall, he always says 3 points and he forgets the third one. I just forgot the third one. Okay, now let me introduce Peggy Davis for the first presentation. She is, of course, a professor at New York University Law School, and her bio is in the materials, too, with a great deal of information about her publications and everything else. So without further ado, I will turn to Professor Davis.
Thank you. Good morning, everyone. I'm just recovering from running from the train, so if I'm a little breathless, forgive me. What I want to talk about today is the idea of a reactive constitutionalism. And I suppose it'll be a little controversial, but I was told that I needed to limit myself to 7 minutes.
7 minutes, exactly.
And so I'm going to do my best to communicate a somewhat complicated thought in 7 minutes. And it's, again, a thought about our Constitution as reactive. Our post-Reconstruction Constitution as reactive, or our reconstructed Constitution as reactive. And I'm going to talk about that in the context of looking at the way the Constitutional Court of South Africa has interpreted its constitution, which is its new constitution, which is, of course, explicitly reactive to apartheid. My argument is that the Reconstruction Amendments created for us a new constitution that was reactive in a similar way to slavery. We had a panel chat by phone recently, and Ted reminded me that the South African Constitution is, in its terms, different in very significant ways than ours. And he's absolutely right, of course. And so I have an uphill battle. It's a battle to persuade you that ideas that have arisen in the context of a constitutionalism that was devotedly reactive are applicable to the interpretation of our Constitution. What I'm hoping for is to identify an idea of human dignity that comes, yes, from examination of systems of oppression, but that is an idea of human dignity and therefore more broadly applicable. I think that that's what's happening in South Africa, and I think that there's nothing in our history or in the text of our Constitution that prevents us from following a similar path. Part of the argument is that people have come to understand freedom, liberty, citizenship by contemplating atrocities and lack of freedom. And that the depth of our understanding of what it means to be a citizen, what it means to be a free person, was enhanced by the experience of slavery, just as the understanding South African people have of human rights was educated by the experience of apartheid. So I'm arguing in part that we reason back from a sense of dissonance to a deeper understanding of fundamental rights that we thought we understood before. Now, the Civil War amendments were, I know that they're being discussed here as having a certain originalism. And so I want to challenge a little bit what that originalism is, which is to say that I read the Reconstruction amendments as anti-slavery amendments, and I read them in light of anti-slavery ideology. And to do that is to do more than take a stand against slavery, but it is to embrace an understanding of human rights that is consistent with anti-slavery ideology. I spent a book some years ago called Neglected Stories documenting the preoccupation that anti-slavery people in general and folks who were debating the content of the Reconstruction amendments, particularly the 14th, had with this understanding of freedom, a broad understanding of freedom that was slavery's opposite, but much more than simple emancipation. And if you accept that, then you accept that the 14th Amendment creates or recreates a charter of rights and liberties that respond to understandings about how it is right to treat human beings in light of the capacity that human beings have and the desires that human beings naturally have. I can't recite the evidence here, but I hope to, well, I feel like I'm constantly going around telling people about these Reconstruction debates. but I can only refer you to the book now for evidence from the debates themselves. Now, of course, I have to admit not only that our Constitution doesn't have the terms that the South African Constitution has, but also that our constitutional history and the history of Reconstruction are problematic in important respects. There are patriarchal and heterocentric strains, religious strains, that pull against some of the broad ideas about human rights for which I'm arguing, and I recognize that. But I think that on the whole, what's happened is that the court certainly, and too many commentators, have bought into a revisionist history of Reconstruction, and that revisionist history was a history designed by the enemies of Reconstruction to narrow its meaning and scope, and that we ought to look again and rethink. Now, I want to turn to the point that there is a basic idea of human dignity to be found in our Constitution. We don't see as much talk about it in the opinions of our Supreme Court as one does in the opinions of the South African Constitutional Court, but we see glimmerings of it even despite the rejection of Reconstruction ideology by the court. And one of the glimpses, of course, is what Justice Scalia calls the sweet mystery of life dictum. But this idea that at the heart of liberty is the right to define one's concept of existence, meaning, and the mystery of human life, and that beliefs about these things should not be constrained by the state, is an important element of this concept of human dignity, which again I understand to be related to people's sense of what all human beings want, are capable of, and are entitled to.
Just about finished.
Okay. I try to illustrate the difference between the South African and U.S. interpretations of what I think of as two reactive constitutions by looking at the opinion in Lawrence against Texas. And I'm over time, unhappily, but I want, so I'll skip over the language from Lawrence, but it is like the sweet mystery language that is general, that speaks in absolutes and is not contextualized. The South African court, deciding the same question, the constitutionality of laws criminalizing sodomy, not in terms of naked absolutes, but in terms that were unhesitatingly informed by South Africa's history of rejection of apartheid. And the court said, therefore, the experience of subordination, of personal subordination above all, lies behind the vision of equality. When it said that, it appealed both to logic and to experience. And when it said that anti-sodomy legislation built insecurity and vulnerability into the daily lives of gay men, just as apartheid once built insecurity and vulnerability into the daily lives of people of color, its words had special resonance, and it exemplified, I believe, the kind of thinking that could become a part of our constitutionalism were we to understand our reconstructed Constitution as being reactive. And I close with saying that it seems to me that we are on the brink of an administration that will help us in ways that I don't have time to elaborate, but I would love to bring the sensibility that says these are matters of fundamental human rights. You won't fully appreciate that until you reach the point at which you are thinking of all the people in the United States as full and equal participants. And you're not thinking of doing things for them, but you're thinking of a collectivity in which we are all identified and for which we all care.
So Professor Davis has given us, elaborated how we should have a broad interpretation, broad theories about not only the 14th Amendment, but our Constitution in general, to encompass a human rights definition. And one of the things the new administration could do is appoint some justices who would agree with that, right? Now I turn to Professor William Eskridge, who is the John Garber Professor of Jurisprudence at Yale, and whose publications are described in the materials you were given, and who was very much involved with the Lawrence case, and the book on gay law was important to that, and he has Gay Marriage for Better or Worse, or for worse, his latest book, which is going to solve the current crisis over gay marriage. Professor Eskridge.
Thank you. I also have a PowerPoint to try to speed things along for me anyway, because I'm very gassy. But I want to express great gratitude to the University of Pennsylvania, the wonderful ACS organization, and to our chair and panelists. My approach, which I think is within the parameters of the discussion yesterday, is going to be more structuralist and purposive, without necessarily hewing, though not ignoring, the original discussions surrounding the Reconstruction amendments. And my theme is going to be pluralism. And I want to start with the Constitution of 1789 as immediately augmented by the Bill of Rights. And it seems to me here is a core concept articulated by both Madison in Federalist 10 and Hamilton in number 78, underlying the philosophy of that document. And that is, in a pluralist democracy was defined more narrowly in those days, policy decisions should be made by elected representatives. But there is a risk that they recognize that factional majorities will adopt, and I'm using Hamilton's language here, partial and unjust laws. Now, what's wrong with partial and unjust laws from the point of view of the framers, the original framers, that they raise the stakes of politics and drive groups away from political engagement. So mine is complementary but very different approach from Professor Davis's. I'm focusing less on dignity and more on the operation of a democratic political system. The theory for this draws very heavily from Machiavelli through Harrington, with whom some of these framers were familiar. Now, here are some pluralism protecting features of the original Constitution. Three ideas. One is that legislatures are the primary forums for deliberation, not just policymaking, but for deliberative policymaking. That was the point behind bicameralism and presentment at the national level, and that's the kind of concept that's loosely embodied in the Guarantee Clause. Second concept was equal and fairly free access of salient groups to the system and neutral rules. Now, I do emphasize that salient groups is a dynamic concept that in a pluralist democracy does change over time. And then the third idea is that there should be no permanent winners or demonized losers or outcasts in the system, an idea that was embodied in the religion clauses. Fast forward. I completely agree with our courageous chair that the focus of the Reconstruction Amendments was race. And indeed, in the wake of the 13th Amendment, the freed slaves needed to be integrated into the body politic, not just for reasons of dignity and humanism, but for good old pluralistic political reasons. And so assurances were most important in that context, and they were immediately important. So if, number one, legislatures were to remain the primary forums for deliberation, then number two, you needed the 14th and 15th Amendments to assure the freed slaves of access to politics, an access that, of course, was very imperfectly delivered. And you also needed the 14th Amendment to give some protection against the Black Codes, regimes that were designed to deal them out of ordinary civil liberties. But note, the 14th Amendment's text does not even mention race, and should be read textually, as well as for other reasons, as a generalization of all three of the pluralism-based precepts that I think are distinct in the original Constitution. Number one, the primacy of legislative deliberation. Number two, free and equal access to politics and state processes. and 3, the idea of no outcasts. Now, such a reading of the Reconstruction Amendments, particularly the 14th, in my opinion, harmonizes the new text with the structure of the then existing Constitution. I think it has 3 other virtues. Virtue number 1, such a reading is suggested by the general purpose of the 14th Amendment in particular, which was not to give federal judges supervisory authority over state lawmaking, Professor Berry's quote from the slaughterhouse cases, but instead to give you the sponsor of the amendment in the Senate to abolish all class legislation in the states and to do away with the injustice of subjecting one caste of persons to a code not applicable to another. Similar anti-class legislation discourse is found plentifully in the state ratifying legislatures, as Bill Nelson has documented. Class legislation is a core violation of the 14th Amendment because it is non-neutral, it raises the stakes of politics, and is exclusionary. That's one virtue, an original meaning one. Second virtue, such a reading is required by the Reconstruction and Constitution's commitment to the perseverance of democracy. Modern political scientists such as Adam Jaworski support the Madison-Hamilton notion that exclusionary, stakes-raising politics that drives pluralist groups from participating in the system is lethal for democracies. And Jaworski reminds us that many, in fact, most democracies do in fact fail. A third virtue, and maybe a questionable one in this group, is that pluralism facilitating theory does capture much of the heterogeneity of the Supreme Court's equal protection and due process jurisprudence, including the Warren Court's jurisprudence, which has allowed most pluralists give and take deals. But the Court's jurisprudence has slowly accommodated new pluralist realities, such as women's entry into American public culture, Craig v. Boren, and has struck down extreme exclusions of disabled persons in Cleburne and of illegal alien children in Plyler versus Doe. Now, much of my theory, and I won't go into this in great detail, my theory is pragmatic, and it's very much influenced by the experience not just of African Americans, but also interestingly the parallel experience of lesbian, gay, bisexual, and transgendered Americans. And for that particular group, there has been an evolution of the 14th Amendment application to the group in 3 stages that are linked to the LGBT group's status in our pluralist society. In stage 1, and these all parallel African American stages, so long as sexual and gender variation was universally considered a malignant variation, as it was for most American history, the Equal Protection Clause did little work for this closeted minority. But the First Amendment and the Due Process Clause, as applied to criminal prosecutions, did protect even these demonized Americans from quote-unquote excessive persecution, enabling us to contrast the anti-gay culture comp here in this country, which is linguistically the same as the culture comp in Nazi Germany, but had very different operation on lesbian, gay, bisexual Americans. Stage 2 is the stage in which homosexuality and even cross-dressing came to be considered tolerable variation in most of the United States, and that was the 90s. At that point, the 14th Amendment was read to protect them against being considered legal outlaws, cases that I cite, including Lawrence. Gay marriage remains too controversial for federal judges, an argument I make in the recent book, and the Supreme Court constitutional recognition would in fact raise the stakes of politics today for traditional family values Americans. Should we despair? Of course not, because there is a stage 3. For that part of America where homosexuality and gender variation are now politically normalized, New England, and I thought California until recently, local constitutions will support complete equality, including gay marriage, as we now have in Connecticut. But LGBT Americans have to earn that equality, at least partly, in the political arena. Pluralism-focused theory will require political and legislative support for same-sex marriage, and I invoke the parallel of Loving versus Virginia, which was not handed down until all states outside the South had repealed their bars to different race marriage. I will just note these, that there are other interesting and important applications of pluralism-based theory of the 14th Amendment. The basic idea is that new social groups, or fresh coalitions of older groups, must earn their stripes in the political process before the Constitution will give them anything more than formal access rights. Consistent with the pluralist theme, however, constitutionalism is and should be dynamic, but new groups or fresh claims are more likely to make progress, more likely, not always likely, under federal superstatutes than under the Constitution. So another take-home theme I have is not only the heterogeneity of groups that are going to be affected by the 14th Amendment, but also the admonition that our focus should be primarily statutory. So the new justices in the Obama administration are going to be most important for how they interpret federal statutes. No more Ledbetters, no more anti-affirmative action interpretations, and instead interpretations the other direction. And let me just mention three groups, and I will only mention the language minorities, where there are some constitutional protections pushing forward. I think those ought to and will expand. But the main protection is in the Voting Rights Act for accommodating language minorities. Felony disenfranchisement, I think a big issue for us. It's an issue where Supreme Court precedent is hostile, but the effect of felon disenfranchisement felt by 1 out of 100 of American adults is a core violation, it seems to me, of the normative commitments in the 14th Amendment.
You got to finish up.
And then finally, family responsibilities, and I'm done.
Okay.
How's that for a
Very
quiet
good.
panel?
Very good. Thank you. Thank you very much. So we got two takes on equal citizenship, which groups? Peggy Davis's, which is all-inclusive in the name of human dignity, and Bill's, which is inclusive based on the concept of pluralism related to other parts of the Constitution, not just the 14th Amendment, but that people have to work for it in the political process. And now we have Professor Shaw, Teddy Shaw from Theodore M. Shaw, from the University of Columbia Law School, who was most recently, before that, Director, Counsel, and President of the NAACP Legal Defense Fund, and was instrumental in the Supreme Court decision in the Michigan affirmative action case. Professor Shaw.
Well, thank you, and again, it's a wonderful opportunity to be here with this august group. I want to talk about the way the post-Reconstruction amendments, particularly the 14th Amendment, have been interpreted and carried forward into the 20th century and now the 21st century battles about race, affirmative action in particular. And in particular, some of the ways in which the jurisprudence of the Supreme Court for the last quarter of a century, actually more than that, but particularly over the last quarter of a century, has strayed from the purposes of the 14th Amendment so far as to really invert the usage of the 14th Amendment in a way that is, in my view, intellectually dishonest. I guess the starting point is to consider briefly that the 14th Amendment, when it was adopted by the 39th Congress, or drafted by the 39th Congress, in the 39th Congress, and that same Congress, as some in this room have wonderfully documented, undertook a whole range of race-conscious actions. The Freedmen's Bureaus set up hospitals and schools for the recently freed slaves, actions that were explicitly race-conscious. The Supreme Court, if we fast forward into the affirmative action cases of the 20th century, the late 20th century, had that information before it in Bakke. There were briefs in Bakke that were very clear on that point. And the Supreme Court ignored those arguments, just didn't even deal with the significance of the fact that the 39th Congress apparently did not think race-conscious measures were per se inconsistent with the 14th Amendment. And of course, this came after the Supreme Court had undertaken 2 years earlier to gratuitously impose on the 14th Amendment. It wasn't the first time that it sent the signal, but to gratuitously impose the intent standard in Washington versus Davis, which put beyond the reach of judicial action a good bit of the structural inequality, what's now called institutional racism. See Chuck Lawrence's groundbreaking article, The Ego, et cetera. And really began to set the stage for repealing what was done in Brown versus Board of Education in a way that left Brown hallowed but hollow. There's this fictional severance of the cause and effect link between the long era of de jure segregation and present-day segregation that leaves massive segregation intact and treats it as if it was accidental, unrelated to its historical antecedent. If we think about the Bakke case itself, of course, it treated so-called benign discrimination in the same way that it treated invidious discrimination. It didn't find that the 14th Amendment had any specific significance for African Americans, even though Professor Eskridge is certainly correct. When we look at the text of the 14th Amendment, it doesn't mention race. For that matter, it doesn't mention intent. Clearly, everybody knows that the 14th Amendment's abiding purpose, as Professor Berry indicated, was said in the slaughterhouse cases, was to bring and protect, to bring into the fullness of political life and protect the civil rights, really, of African Americans, the recently freed slaves. I said political rights. Political rights really were more accurately addressed in the 15th Amendment because, of course, at that time, the 14th Amendment was thought to address civil rights at that time and not the right to vote, not political rights, and that's why we needed a 15th Amendment. If we look at Bakke, and we have this treatment of the 14th Amendment that is ahistorical and decontextualized, and we have a decision that shifts the interests that are at stake in the diversity discussion, to create a diversity discussion, to shift it from equal protection, to shift the interest from black and brown people who were subjugated under a system of white supremacy, either through slavery or de jure segregation and discrimination. We then come out of Bakke with a shift to the First Amendment interest of institutions in diversity as a matter of academic freedom, which I'll take as an alternative basis for race-conscious actions to bring about diversity, but it's a complete abandonment of the purposes of the 14th Amendment as it applies to the issue of access to higher education, by one example. And when we couple that with the abandonment of school desegregation, even now using the 14th Amendment to invalidate voluntary integration methods that were found to be insufficient standing by themselves in Green v. New Kent County in 1968. But they become now a cause for constitutional infirmity. We have to see a corruption of the 14th Amendment. When Professor Eskridge was setting forward or setting out the underlying theory of pluralism and the way that the founders anticipated ensuring that all citizens participate in the democracy, I thought about footnote 4 in Caroline Products, which in many respects was the ignited current 14th Amendment jurisprudence as manifested in the 14th Amendment's Equal Protection Clause. And of course, the theory there was that there are certain insular groups that can't win in the political process. And we project that now into the battles of the Voting Rights Act, which we recently extended, but then look at it through the lens of the election a few days ago. As I was saying last night at the Constitution Center, I think that there's going to be a long period of reexamination of those principles as a matter of political theory as well as a matter of law. We're not going to sort through this for some time, but there is a significant paradigm shift that may be underway. One more thought before closing. Professor Eskridge talked about the possibilities and expectations of what judges appointed by an Obama administration will do. We all, well, I don't want to be presumptuous. Many of us hope for that. But I think it's it probably is too much to expect that the body of case law that has been adopted over the last half a century, and the case law that I talked about from Bakke forward, that has inverted the purposes of the 14th Amendment and completely ignored its original intent. It's probably too much to think that we are going to see that wiped away overnight. And even if we saw judges appointed who interpreted the 14th Amendment in a way that's more consistent with its original intent, in school desegregation, for example, it's not going to be possible to go back and pick up where we left off when school desegregation became subverted by the Supreme Court's decision in the Jenkins case in Dowell, in Pitts versus Freeman. We have to start in a new place and to look at the segregation that remains intact, the inequality, in spite of the fact that we've elected the first African American as President of the United States. All of that didn't change overnight. And the question is how a more faithfully interpreted 14th Amendment Equal Protection Clause is going to apply. Exciting times. I look forward to seeing it. But the warning is that everyone, well, not quite everyone, many people are projecting into Barack Obama and his administration all of their hopes, dreams, aspirations, yearnings. They can't all possibly be met. But it's our job. I don't have to, you know, I should confess in this, the last thing I'll say is that I'm too recently out of advocacy now that I'm in academia to be what academics think of as dispassionate. And so I don't pretend to be. So I'll say it's our job to make sure that we push this new administration from the outside, those of us who don't go in it, to make sure that it does what we believe it ought to do and goes in the direction we believe it ought to go.
Thank you, Professor Shaw. Now, Serena Myrie, who is a professor here in the law school at the University of Pennsylvania, is going to answer a question that has always puzzled me. We can't stop people from analogizing, but usually folks want to analogize from the experiences of African Americans after the law is broadly interpreted to protect the rights of African Americans. That's my impression, that no one wanted to analogize to African Americans when it didn't. But she's going to tell me whether that's true or not, and whether, you know, give me the real story. Come on, Serena, tell me.
Thank you. Well, I also wanted to thank ACS and everyone here, and it's really an honor to be on a panel with so many distinguished panelists. One of the questions that our panel was asked to consider is whether extensions of the Equal Protections Clause protection must always be accomplished by reference or analogy to the paradigm case of race. And whether or not this is an imperative, it seems like a reasonably good, if perhaps partial, description of what's actually happened. So paradigms developed in response to struggles for racial justice have shaped the ways that various other groups have articulated and prosecuted constitutional and other equality claims. I'm using as a shorthand for this phenomenon reasoning from race, and my work is particularly focused on how this is played out in terms of in the context of second wave feminism. So by reasoning from race, just to define that term briefly, I'm talking about at least 3 different but related strategies. So reasoning from race, of course, can be a rhetorical strategy, drawing analogies between race and other categories, sex in my example, but certainly other categories as well, in order to convince various audiences that new claims are worthy of similar attention and remediation as older claims, claims based on race. It's, of course, also been a legal strategy, relying on precedents, organizational models, and institutions that were developed in the race context and extending them to new claims and categories. And finally, I'd like to argue that reasoning from race has also been a powerful, if somewhat problematic, coalition-building strategy, effectively tying together the fates of various groups who otherwise might find themselves and have found themselves with divergent priorities and in competition for scarce resources. And as Professor Berry noted, of course, the perceived desirability of relying on the paradigm case of race has varied historically along with the content and efficacy of that paradigm. So reasoning from race, I think, first seemed an attractive strategy to women's rights advocates during Reconstruction. 19th century women's rights advocates famously compared their claims to those of the freedmen in an effort to reap the benefits of the Reconstruction amendments. And in so doing, they often emphasized at that time the need to enfranchise black women in particular in order to fulfill the promise of emancipation. Well, not only the exclusion of women from the Reconstruction amendments, but of course the demise of Reconstruction itself and the rise of Jim Crow substantially devalued this reasoning from race as a rhetorical and legal strategy. And moreover, it really decimated the short-lived coalition between white women's advocates on the one hand and African Americans on the other, African Americans including both advocates for women and advocates for racial justice generally. Apart from some isolated instances of convergence, it really wasn't until the early 1960s, the second Reconstruction, that the race paradigm again seemed a promising template for feminist claims. In my work, I look at, in particular, an African-American feminist lawyer named Pauline Murray, and argue that she was largely responsible for formulating a new feminist legal strategy based on this idea of reasoning from race. Murray believed at this particular historical moment of the early 60s that pursuing constitutional and statutory change for women through an analogy to race would, among other things, unite a civil rights movement largely focused on restoring the rights of African American men on the one hand, with a predominantly white women's movement on the other, and importantly place African American women at the center rather than the margins of both of these movements. Murray, interestingly, drew explicitly and frequently on the legacy of the first Reconstruction, mainly as a cautionary tale. She was acutely aware that the last time feminists tried to piggyback on the gains achieved by African American men, things hadn't really gone very well for either group. She warned her colleagues in both movements against alienating one another lest they lose crucial allies and, moreover, compromise the promise of both movements for women of color in particular. In the era of the Moynihan Report and concerns about black matriarchy, she and other African American feminists made the case to their civil rights colleagues that the empowerment of women was a crucial component of racial progress rather than its enemy. Now, second-wave feminist lawyers and activists enjoyed considerable success in incorporating a particular version of sex equality into the Equal Protection Clause, and at least as importantly, as Professor Eskridge notes, into statutes, like super statutes in particular, like Title VII. By the mid-1970s, I think their reliance on the race paradigm was running into trouble for a variety of reasons. Conditions of scarcity made competition between disadvantaged groups for resources and jobs particularly acute, something that we might be able to relate to today. Judges and other legal decision makers began to make the analogy to race compulsory. In other words, if the harm didn't resemble a particular conception of racial oppression, it wasn't cognizable. And very importantly, beginning in the mid to late 70s, as Professor Shaw just alluded to, race jurisprudence itself was becoming increasingly conservative. Feminists could do much less with a color blindness or intent-focused model than with an anti-caste version of the race paradigm. And though Pauline Murray had reintroduced the race-sex parallel in large part to focus attention on the experiences of African American women in particular, once the analogy became partially codified into law, it tended to become increasingly abstract, obscuring rather than highlighting interconnections between race and sex inequality. And last but not least, concerns were building on the race paradigm entailed dangers for the original claimants as well, African Americans in particular, including but not limited to a narrowing or undermining of the original claim. But lest the story of second-wave feminism seem like another cautionary tale, a sort of reincarnation of some of the failures of the first Reconstruction, I would like to suggest that the historical trajectory of second-wave feminism's experiment with reasoning from race is more complicated than a narrative of initial promise followed by crushing disappointment. Instead, I think advocates have found creative ways, and have found creative ways to reformulate their arguments and enrich both their own discourses and our understanding of race, status, and inequality. Sometimes that takes the form of manipulating legal precedent. One example that Professor Shah's presentation brings to mind is feminist attempts in the 1970s and since to use the arguably more flexible jurisprudence of sex equality law to provide precedent and justification for race-based affirmative action. I can say more about that if people are interested. On a more theoretical level, I think it's easy to think of many instances in which insights about the experience of other outgroups, women, sexual minorities, the disabled, et cetera, can shed light and critical perspective on the claims of African Americans and how they might be, have become impoverished and might be expanded. And notably, I think there are many rich historical examples of coalition building based on shared claims, not the least of which is the tradition of African American feminists who have used the interconnections between various forms of injustice to argue for more expansive visions of equality and justice along the dimensions of race, gender, sexuality, and class simultaneously. And I think an important point to keep in mind is the ways in which the very act of tying the fates of groups and movements together through common legal tools, whether it's the Equal Protection Clause, the 14th Amendment more generally, or statutes like Title VII and others, has arguably sustained coalitions that otherwise might succumb to divisions over strategy and substance. I think I'm running out of time, so I just would suggest that one important legacy of Reconstruction that is worthy of our attention is that among the failures and disappointments that cried out for redemption a century later was this rupture between racial justice and feminism. And while the Second Reconstruction inevitably fell short in many ways, the extent to which Polly Murray and her allies and successors restored the promise of this nascent alliance is an important measure of its success, albeit incomplete. Thanks.
Okay. All right. We have given much food for thought and discussion, and at this point, we'd like to entertain some questions or comments, brief, not speeches, from those of you who are out there. Many of you are expert on some of these matters, yes, and some of you are inexpert, but you know about them or have good questions, yes.
Hi, I have basically
And could you say who you are?
Jamal Green at Columbia Law School.
Okay.
A comment and a question, a brief comment. The comment is kind of a footnote to Professor Mayeri's presentation, which is that one of the, I think we've seen perhaps with Proposition 8, one of the perils of relying on the race paradigm is that it can generate a certain resentment among certain groups, particularly African Americans, for whom that comparison sometimes makes the group lose credibility within that community. The question is primarily for Professor Eskridge, which is, given the themes of this conference, I wonder how much work the text and original understanding of the 14th Amendment does in your story. It seems maybe a bit awkward to rely on an amendment that was not understood to protect political rights, as Professor Shaw mentioned, to generate a pluralistic discourse related to political participation. And as Professor Mayeri points out, of course, much of the rights discourse that generates your story comes from the Third Reconstruction, comes from the Civil Rights era. You know, you mentioned Loving. And so I just wonder whether original understanding is doing any work for you.
Well, I think there are three things I want to say about that. One is that the original text, I think, does a ton of work for me, and for the reasons that I've given. The second point is I'm making a specific distinction in my talk. There are three different levels you can talk about original intent. You can think about specific intent, and I briefly mentioned that, though I don't think that's what we should be relying on. You know, they intended to protect certain groups. They intended to outlaw class legislation. They intended to protect African Americans. The second level of intent is what I'm focusing on, and that's general intent, the purpose. And I think that does a heap of work, in my opinion. And it's not just limited, I would submit, to what used to be known as civil rights, at least in the light of precedent. Because the Due Process Clause, as we all know, now protects a heap of political rights, including voting in some circumstances, certainly including political activities, et cetera, et cetera. So yeah, you always have to look at it evolutively, but I would suggest that the original purpose is a really noble purpose and ought to inspire us. Thirdly, and this is my third point, then there's a level of meta-intent, since we're both Yale types. And the level of meta-intent, I think, is the ground norm of the Constitution, in my opinion, is still the pluralism idea, pluralist democracy. I think that's the overriding thing. And that's why I would say that whatever the groups we're talking about, whether we're talking about racial groups or sexual minorities or women who've been particularly successful, we need to follow a multi-institutional strategy. And so constitutional cases, absolutely, like Cleburne and Romer and Lawrence particularly, a great case where the political process has been blocked. But the fact of the matter is, and this is actually the main opportunity the Obama administration offers us. If it weren't for the fact that the economy has collapsed and we're engaged in a $2 trillion war in Asia, except for those two facts, the real opportunity, this is a problem. This is a problem. The real opportunity is that there is an overwhelmingly Democratic Congress, or at least substantially Democratic Congress, and a Democratic president. I don't think this is going to happen tomorrow. So the heavy lifting is going to have to be done, in my opinion, by Congress, by state legislatures. The real abomination that none of us mentioned is parents involved. That's the biggest abomination. Ted, friendly amendment. I bet you will agree that that's the worst decision in many ways, because it cuts off robust, democratic, pluralistic dialogue at the local level, which is supposed to be federalism. It's supposed to be the original intent you talked about, raw judicial activism overriding that. And that needs to be the focus of sustained political attention as well as judicial attention. So not just Congress, but also local legislatures, like school boards and
I
stuff.
thought one of the answers to his question was that you were relying not so much on the 14th Amendment, but a whole lot of history of the Constitution before that,
Yes,
which
ma'am.
is where your pluralism, that was the answer, one of the answers to your question. But I wondered, as you were talking, how far the concept that Peggy talked about of human dignity as a basis in human rights, including everybody, and your pluralism, how far are you willing to go? For example, on sexual matters, not just gays, lesbians, and transgenders, but how about a theory that anyone who has sexual expression consensually that some of us may not have thought of, you know, fetishes or all kinds of things, as long as it's consensual, should not have legal sanctions against that, and that their right to sexual freedom would be protected either as an aspect of human dignity or in your concept of plural. I'm just trying to see how far you would take this.
Well, okay, not that my opinion really matters, but here's how I would take it. And by the way, I would personally distinguish between where we should take it in the political process in terms of advocacy versus what a court is going to enforce. Well, I think there are three levels. One is that I think most of that is probably protected by a reading of Lawrence. If you want to talk about fetishes and stuff like that, watching movies is to a certain extent in the home protected by Stanley, to the extent that that's still good law. So I think a lot of that's the first level. Second level of analysis is that the point of dignity, it seems to me, is always complicated by the fact that dignity for me might require indignity for somebody else. No, I'm not kidding. And you have to interrogate the concept of consent. And so there are some people who believe that sexual intercourse between, say, a teacher, a 30-year-old teacher, and, say, an 18-year-old student, or say, a 21-year-old law student, take either of those examples, is consensual. I personally am not so sure. I bet you we have heterogeneity in this room on that issue. I'm on the, no, it's not consensual from my point of view. And I think it's a dignitary question. So I think dignity is a useful vocabulary. So that's the second thing. The third thing is that there are some issues, and this is really getting deep in it, but why don't I let the genie out of the bag since you've asked? And that is that there is a politics of disgust that has always mobilized Americans on all of these issues, including brainy judges and cerebral law professors. And I'll give you an example. I give a quiz to my students whenever I teach con law. Exactly your question, Professor. And I give them a laundry list of all sorts of different variations of sexual activity in the home, in the car, et cetera, et cetera. And one of them is always sex with a barnyard animal in the barn. So in other words, it's not open, and et cetera, et cetera. And the students, of course, lesbians, great. Often the 30-year-old person, the 18-year-old person, fine with them, many of them. And so fornication, no problemo. Often adultery, get a good split among the students there. 80% to more of the students will say no to the barnyard
Okay,
thing.
up with this with one.
And I say, why? Because your consent seems to be your template on all these other things. They say, Professor, I said, it's not consensual. And I said, well, what did you have for lunch today? And many of them will have had hamburger. I said, was that consensual? That's cannibalism, if you want to interrogate. But then the students will, being bright students, they will come back with, but there are third-party effects on children. And indeed, students bombard me one year. Here are empirical studies showing a link between sex with animals and then predation against children.
I got my answer, Bill. Thank you.
Okay.
I want to jump in.
Sorry.
Thank you. For me, the answer with respect to barnyard animals or anything else is less important than the question. And what I'm arguing is that if you ask the question in terms of human rights, you engender a very profound conversation, and one that I think is terrifically productive. Now, I completely agree with Bill that in the political process, we have to struggle to vindicate the rights of groups that we care about and not count on a commitment to human rights that will protect everyone. But as a matter of constitutional principle, and as a matter of asking, for example, do you want an Obama court to think of itself as vindicating the rights of African Americans, or do you want an Obama court to think of itself as moving to an understanding of human rights that is informed by the experiences of racism, sexism, etc.? For me, the answer is clear.
Okay, question, yes.
Do people in this
You
room...
have to say who you are.
my name is Mark Graber, University of Maryland. Do people in this room really want the rights of gay marriage, affirmative action, the right of people to decent housing, to be dependent on what I find in people like me from disciplinary traditions, political science, and history when we go to the library and open up the Congressional Globe? It's a variation of Neil Siegel's question. And just to understand some of the disciplinary traditions we come from. I've never seen human dignity or pluralism writ large when I've opened the Congressional Globe. What people like me see are lots of conflicting and diverse strands of thought. Even when a constitutional amendment is adopted, we don't see anything that resembles original meaning. We do see sometimes strands of thought that have a family relationship that with a lot of evolution might become anti-subordination, but they're not anti-subordination, say, in 1868. And we see lots of strands of thought that have no valence for anybody. at this time that when we see the framers, we see people who wear funny wigs. And so one notion is, should people like me who are progressives simply get into another line of work? And I say this very seriously, that when I read Jack Balkin, Jack terrifies me, because I'm worried someone might take my words and say, I don't see the original meaning here, and deny somebody a fundamental right. Or should we do what I think a lot of historians in political science would like and say, it's not that we are the only heirs to 1868, but this is a path from 1868 to the present, and it's the most desirable path for reasons in the present, and not necessarily because Abraham Lincoln, Lyman Trumbull, or John Bingham would have thought the path most desirable.
Okay, yes. Yeah. That was a comment, so that's what.
Yeah, I had a question which I think ties
Yeah.
Pam Carlin from Stanford.
Yes, I know.
I have a question that ties together something that I think was implicit in all four of the presentations, which is when you talk about equal protection, you're usually talking about something comparative. And so the question is whether what you're trying to do is to give other groups the same thing that the dominant group already has, or whether you're trying to get something that's equivalent in terms of the value to that group. And I think this is probably in Serena and Peggy's presentations and Bill's more than Ted's, but let me just put it to you this way, which is you could be saying women deserve the same thing men have, which is a kind of sameness feminism versus difference feminism. You could be saying, in terms of marriage, gay couples should get the same institution that straight couples get. And there's a lot of debate in the LGBT community about whether what people want is marriage or what they want is a bundle of protective rights without the trademark. And you could be saying, in terms of human rights, something about a real profound debate about what counts as human rights, or you could just be saying subordinated groups should get the same rights that the dominant groups have already had. And so I wondered if people on the panel might speculate about the relationship between sameness difference and the stress that we're putting on equality and equal protection.
Who would like to, and is it, to add one more question to Pam's question, is it a question of whether what the people who are involved say they want or not? I just added that to the rest of them. Who would like to tackle this? Do you
Well,
want to, Ted?
Pam, I'd actually made a note even before you asked that question about exactly that point, the issue that many of us wrestle with, which other constitutions and international norms and principles and other documents have reached more clarity on. That what we're talking about, that equality doesn't necessarily mean that people should be treated exactly the same. In our jurisprudence, as you know, I think the principle has been sameness. It's what allows, I think, the court to reach decisions which leave people in unequal positions, sanguine in the knowledge that they've applied or it's applied some kind of formalism that masks itself as equality. Is there a basis for reading into our Constitution, as Peggy has indicated, some concept of human dignity? I want it to be there. I'm not sure it's there. I think we can stretch and interpret it that way. I think about Charles Black and some of his writings about trying to find a basis for economic protection. Think about the Ninth Amendment, whether we can pour something into that empty vessel. It's been intellectually stimulating, but it hasn't had any practical resonance in our jurisprudence. While I have my mouth open, I just want to point to one other thing. that came into my mind when we talked about the race discourse as a wellspring for other groups for their struggles and discourse. And we all know that white women were in the pre-Civil War arena rather, the primary advocates, notwithstanding Garrison and abolitionists who were male. They were the primary advocates of abolition. But when I think about the 20th century jurisprudence, late 20th century jurisprudence, I think about Croson, for example. And Croson put African Americans into a real trap. On the one hand, as a political matter, if they did not carry other groups with them, whether it's gender or other ethnic groups, Aleuts, Latinos, there would not have been enough political traction to support affirmative action programs. On the other hand, when they included all those groups, they ran into the narrow tailoring trap. It was impossible to win. If you look at Croson more carefully, theoretically, women were in a better position, theoretically, given the three-tiered analysis of equal protection principles, because strict scrutiny should not have applied to women. The intermediate level of scrutiny should have applied, so theoretically, the affirmative action programs, the contracting programs that were aimed at them should have been easier to sustain and uphold, although as a practical matter, I don't know that that's where it ended up. The point I'm making is that there have always been all kinds of tensions that have been engendered by the jurisprudence of the Supreme Court that put these groups, even though they were politically aligned, at odds with each other to some degree because of the jurisprudence. I just wanted to underscore that point.
I don't know. Yes, you can respond.
Jump in for a second.
Go ahead. Go ahead.
Okay.
Go ahead.
One thing I want to say is that when I talk about a concept of human dignity, I am less focused than other panelists on the Equal Protection Clause, but more focused on due process and privileges and immunities. But again, I want to point to the kind of conversation that we open, and this is relevant to all three of those areas. Is it a conversation that compares rights or compares goods and stuff and asks if everybody has the same rights and goods and stuff? Or is it a conversation in which you are inquiring about the nature of human beings living in a community and asking what we think they're fundamentally entitled to? We don't look to Reconstruction history because it is determinative, but we look to Reconstruction history because it is part of a process that we see over time of people reacting to history and principles evolving in light of that reaction. So I think nobody here is a strict originalist. And I'm certainly not talking about sameness. I mean, one of the wonderful things about the South African Constitutional Court's understanding of human dignity is that it gives them a ready, easy, natural justification for affirmative action. And, I want that conversation to be going on here.
Okay. Let me relate those two questions. I think they're related. Pick up on Peggy's point. I think it's a process. So, Mark, it's a process by which groups relate themselves to the original purposes. And I would insist on purposes. And then the purposes that have been understood over time, and as they've changed, as Serena has pointed out. And then, Pam, to your question, it is the group's interaction of that purpose over a lengthy period of time. Within the African American community, interracial marriage was not like a gimme. That was very controversial within the NAACP. There were conversations over time within that community, as I understand it, from the history books, that generated these challenges, ultimately ending up in Loving versus Virginia. In the lesbian and gay community, there's some disagreement as to what kind of institution we should have. There's very little disagreement that if an institution is provided for different-sex couples, it should not also be provided for same-sex couples. And most of us also believe that any institutions like domestic partnership that are provided for same-sex couples should also be provided for different-sex couples. And indeed, where we're going is a menu. So that's the third point, is these conversations do evolve in ways that the groups don't intend, and that does produce ironies and dissonances.
I'm told I can have one more question, so who is the, yes?
Thanks. It's Reva Siegel. First of all, it's a great and wide-ranging discussion. Peggy, first, I want to say to people that Peggy's historicism is just the most lively example of how to be in this epic and not do it in an originalist kind of way. And I think there's wonderful opportunities for visiting the history for its various provocations and attempts to, and ways that it can disrupt the ways that we currently know the Reconstruction amendments without viewing the history as a source of constraint in the ways that sometimes, at least, where's Jack, but not always, wherever he is, originalism might mean. On the dignity point, I guess what I'm listening to, I just did a piece using the dignity language in Casey and Lawrence and parents involved. Given the court and given Justice Kennedy's possible movement in some of these areas, there might be a reason to focus on that story and his opinions. And an interesting effect of it is that it also opens our law into more transnational conversations, and that's salutary, I think, in its own right. It doesn't seem to me that it has to be a sole path of doctrinal elaboration, but it also may have the power, the dignity frame, to draw new connections and develop new lines of doctrinal possibility in some areas, and that's a much longer conversation. The South African point that you raised just prompted one thought to my mind. A couple weeks ago, I was talking to Elvie Sachs about the preamble to the South African Constitution, which is really expressly a transitional justice kind of statement of purpose for the Constitution. And I was thinking about, in preparation for this panel, reading some of the abolitionists' thought about Reconstruction. They very much emphasize our preamble to our Constitution as a source of law, and it was a form, I guess, of popular constitutionalism they used to argue against slavery. And that's just a thought that we might, in this process, look to unelaborated pieces of text as sources of new conversation. I take some of the panels this afternoon to be doing that.
All right. Well, thank you very much. We are somewhat over time, but not too much. This was very enjoyable. Thank the panelists. Thank everyone. Have a break.
And thanks to the chair.
Okay, Bill.